We're going to talk about business entities with emphasis on the business entities for a practitioner. I'm assuming some of you want to start your own business and you want to obviously have the right kind of business entity for yourself. So we're going to cover a little bit on it. And first of all, I want to make some comments. Too often individuals jump too quickly setting up a corporation or a partnership. And it's because that's the way the company they worked for was, or maybe it was because someone told them to do it, or they thought it would save money, or whatever reason. We really have to think it out, and the way we think it out is part of our business plan. Our business plan is created, and the business plan and what our objectives are, etc., should really tell us a lot about what we should have as far as what type of business we want, as far as the entity type. And therefore, I would say that if you've got a good business plan started, you might take that to the attorney and show him what you have so he can advise which is the best for you based on the type of venture you're going into. They can also discuss with you the tax consequences, because the tax rates, let's face it, irrespective of what the rates are when you add the state, the federal, and all the other fees, etc., you pay will be a substantial part of your profits. As I put it, is the government owns the business, and they allow me to have a little bit of it, and that's true for anybody in business for themselves when you take account all the fees, etc. And the attorneys are good at figuring what type is best for you, what also saves you for the minimum amount of administration you need to run the business. The most common types are sole proprietorship, general partnership, limited liability company, S Corp and C Corp, and these are set up under state laws, and your attorney will tell you which law, which state to use, which is beneficial for you. Now, in this case of the sole proprietorship and general partnership, it'll probably be your state of domicile where you have your business, but in the case of the others, you may find they have a different advice. Again, they're basing it on what your particular fact situation is. So if you don't give them a lot of information, they're probably going to pick the wrong state for you and the wrong type of entity. So you have to give them your business plan, what your plans are, and you don't keep things out, your secrets. There should not be a secret to your business attorney when it deals with areas of how you're going to run your business. For federal taxes, under there's only several entity types that you can have. Again, there's one set for legal liability, and for following state laws, which we just talked about. For taxes, we only have four types: sole proprietorship, partnership, S Corp, and C Corp. Those are the choices. Now, in addition, if it's a corporation, personal service corporation rules apply, which is a flat 35% tax. And let's face it, that's a steep tax, and therefore your attorney will give you ways to get around it for tax purposes. Now, if you're a lawyer, you cannot, and a law firm cannot get around it, but for financial planners, there's several easy ways to get around that flat tax if you become a corporation. And then the advice might be, in many cases it is you're starting out, you don't know if you're going to make any money for a while, start as a sole proprietorship, there's not a lot you could get sued on, etc. And then gradually, maybe after 6 months, a year, or 2 years, whatever, you go to a different type of ownership. It's very common to do that. And that should be in your business plan too, from what you get from the attorney. The most common, starting out by financial planners doing their own business, is sole proprietorship. And as I mentioned, once you've actually got a business entity going and you're going to be a real business and you'll be able to survive, then you're going to a different business type, which should be in your business plan and came from your attorney. A major task of having the state, local, and federal government requirements as to business licenses, permits, professional licenses, and fictitious names. It's pretty easy. And business dies at the death of the owner. There's some experts recommend a standby trust, take effect at death, and have the trustee take over ownership. Now, I would say for small sole proprietorship financial planning organizations starting out, early stage, if you died, quite honestly, there's nothing really to pass on. So I wouldn't be a big deal about the trust. But let's say you decide for some reason that even if you're successful, you want to be a sole proprietor, that's when that would come in as an issue. Although I think that would probably be very rare because of liability purpose, nothing else. General partnership is also very common. It's when two or more work together to make a profit. I might note there are times we don't realize we're in a partnership, but by our formality or informality, it doesn't matter. If you get sued because they can prove you and someone else or other parties were working together towards profit, you have an informal partnership. What I suggest always is any time you have a partnership, get it in writing, a written agreement, and make sure it complies with the state law. And therefore, it's going to make it much more difficult for them clients to be able to claim that you were in partnership with somebody because of the way you acted. And this is the most risky business entity, as partners are responsible for the action of their other partners. As I put it, if you want to be a partner, be the poorest, the unluckiest, the dumbest, the worst type of person of all the partners, and then you have a partnership. But if you got a lot of money, and etc., it's going to be in your disadvantage because any partner can get you in trouble. Limited liability company, probably the fastest growing as well as the newest business type. Very flexible, low risk. Can be even one person in most states. It says some states, but most states today. The owners are called members, not shareholders or owners. They're called members. And many professionals recommend liability status for new businesses. And note, if it's not an entity, it is not an entity for federal income tax purposes. So you either be taxed as a corporation or as a partnership, or if you're individual sole proprietorship. I might know that the advantage I saw, and I got involved here, is I had a tax business in Oxnard, and a friend of mine had a tax business in West Hills, and another friend of mine had it in Chatsworth. And we were all small, obviously, but by combining and the limited liability company, we were able to say we have 3 offices for our tax business, and that made it look like we were a big company. And yet we each independently ran our company, and we were a valid limited liability company. And that's a big advantage for those of you who might be you want to have your individual business, but you see the advantage of having multiple locations or multiple members. Limited liability is your answer. S corporations, they're only found in the tax code in very few states, California being one. It is not a legal entity, but a type of corporation for tax purposes. In other words, it's a tax vehicle. Big advantage, it says bid, but it should say big advantage is the pass-through of profits and losses to the owners. Unlike a corporation losses have to be carried forward, where if you're an active member of the firm, you will be able to take the tax losses. Subject to passive loss rules, which makes it not always suitable for owners. If you're not a participant, you just own one of the owners, the passive loss rule does not help you. And finally, less paperwork to the IRS, but there are many restrictions as to ownership of S corporations. And I personally have found for myself that they were not very successful because it was very hard to raise money, and people were reluctant to deal with something that was so limited as to who could be partners or owners of it. Very restrictive. C Corp is the less common type of ownership entity, but by far the biggest impact on our economy. It's best for protecting your ownership from lawsuit liability, as management and ownership is separate. It can be an administrative nightmare depending on what state you're located in, and including California, by the way. Substantial benefits by picking the right state for incorporation. So my corporations, based on the advice of my lawyers, have been Arizona in one case, Idaho in another, and Arkansas in another. Now, why they picked that, I don't know. but they picked a state that for what I was doing was the right state for minimizing my paperwork and all that other stuff that goes with the corporation. So, some major decisions. Business entity type determines your liability risk. The tax business entity type determines if you pay taxes or it's flow down to the owners. And again, big difference between a C owner, corp owner versus the S corp. C corps pay taxes on income, and the owners only pay taxes on the dividends received. So there's a big difference also on when you're having capital investment being made as to what the impact is on the owners. And next one is only business type that can really transfer ownership is a C corp. All the others have a little bit more complexity involved in transferring the ownership. And use of online services or an attorney for setting up the entity is a major decision, or rarely is the former the answer. Getting an actual attorney to do for you is much better. You get the right states involved. That have a daughter who used their attorney. They used an online service to set up their business. They're located in Washington. They wound up being incorporated in Washington. They would have been much better off incorporating some other states, and for multiple reasons that we can't get into right here. So again, legal advice is well worth it rather than paying the $98 for getting online. Conclusion: the students should, after taking the second week, all business and need lawyers who are familiar with a particular trade or business. The business lawyer should be invited to be a member of the advisory council for the company, and even in the board of directors, by the way. There are many ways to reduce the possibility of litigation. Documentation is by far the most important thing you can do, and doing it right. And sometimes you have to be trained to do documentation right. That's worth taking the training. Attorney advice is very useful when choosing a business entity. Recommend that the attorney also set up the entity so that you've got the right wording and the right the documentation that you need, and you'll save yourself a lot of time and energy in the long run.